Good afternoon and welcome to this session of the Joint Committee on Human Rights. And as our name suggests, half of our members are members of the House of Lords and half are members of the House of Commons, MPs. And we are concerned with human rights. And we're conducting an inquiry into the issue of the Human Rights Act, which government has established an independent. I've got anybody. Can people hear me okay? Okay.
Echo, Harriet, that's the only trouble.
Right. Shall I quickly start again? Just welcoming everybody. That sounds a bit better. Just welcome everybody to this session of the Joint Committee on Human Rights. Half of our members are House of Lords members and half are members of Parliament, and we're concerned about human rights. The government has, following their manifesto commitment, established a review into the Human Rights Act, and we're undertaking an inquiry in order to feed into and contribute to that review. We have heard from senior members of the police, of the Crown Prosecution Service, from the UK judiciary, from the European Court judiciary, from Parliament's authorities, and this is our final panel, and we're delighted that we've been joined by, to give evidence, four very eminent witnesses. We have Helen Mountfield, QC from Matrix Chambers, who specialised in particularly equality law, law relating to terrorism and national security, education, social welfare and election law, all very germane to human rights. And of course, she's also principal of Mansfield College, which has the Institute of Human Rights. So thank you very much for joining us, Helen. We've got Joshua Rosenberg, who's long-standing legal expert, legal commentator, journalist, honorary Queen's Counsel, honorary Master of the Bench at Gray's Inn, and currently presenting, though I say it myself, an extremely excellent Law in Action series on BBC. Thank you for joining us, Joshua. We've also got Richard Hermer, QC, who's been involved in many of the major claims involving human rights emanating from the Iraq conflict, involving questions around the Ministry of Defence, mistreatment of civilians, acting on behalf of injured servicemen, testing the issues around the principle of combat immunity, very much germane issues to human rights. So thank you very much for joining us, Richard. And from Sheffield, we have Professor Graham Gee. Thank you very much indeed for joining us. And you'll be particularly welcome in this session because of the work that you've done looking at the changing nature and character of the UK Constitution. And of course, the Human Rights Act affects public authorities, affects Parliament, affects our courts and the rule of law. So thank you all very much indeed for joining us. So what we're looking at is what are the problems with the Human Rights Act, and I think that it's evident from the government's review that the government their starting point is that there are problems. So what are these problems? Are they real or are they illusory? And we look forward to hearing from our panel on that. Or are there indeed benefits of the Human Rights Act that we should be focusing on and recognising and highlighting? So perhaps I could start with asking, so that we can understand the impact of the Human Rights Act, a sort of before and after situation in terms of enforcement of human rights. We've all obviously long-standing signatories to the European Convention on Human Rights, but what impact did the Human Rights Act have on people's ability to enforce their convention rights after the Human Rights Act was brought into force compared to before we had the Human Rights Act? And perhaps if I can start by asking Joshua to talk to us about that. Joshua.
The impact was huge. It's simply that before the Act came into force, you had to go to Strasbourg to enforce your human rights. You had to take the United Kingdom government to the Human Rights Court and enforce your rights. And the case that springs to mind is the one about gay service personnel There was a rule that if you were known to be gay, you couldn't serve in Her Majesty's Armed Forces. And that was challenged by service personnel. They lost in the United Kingdom, and it was known that if they took their case to the Human Rights Court, they would win. They did, and the government changed the law. But they had to go to Strasbourg to win their case.
Thank you. And what would the situation now be since the Human Rights Act's come into force?
They simply bring an action in the domestic courts, the courts of the United Kingdom, and the Human Rights Convention can be applied by judges in the United Kingdom, and there's no need to go to Strasbourg. And the consequence of that, of course, is that the UK loses very few cases in the Human Rights Court, only 2 last year, proportionally the lowest number, and that's because there's no need to take the UK to the Strasbourg Court. You can simply take action under the Human Rights Convention as applied by the Human Rights Act 1998 and bring your case in the domestic courts. And if you have a right that the government or public authority isn't protecting, then you'll win your case and no need to go to Strasbourg.
Thank you. Can we hear from any of our other witnesses who'd like to respond to that question?
Chair, might I come in?
Yes, please do.
So, I mean, I think Joshua is right in respect of convention rights, that prior to the enactment of the Human Rights Act, these were not enforceable in domestic courts. And one of the aims of the Human Rights Act was to render it possible for individuals to be able to bring a claim in domestic courts without having to do that recourse to Strasbourg that Joshua outlined. I think there is a danger, though, in focusing purely on convention rights, and one's thinking about the protection of human rights more broadly before 1998, because there was, of course, protections through statute law, through common law, as well as being able for the courts to be able to make a reliance on or draw on the Strasbourg case law. So it was a multi-layered approach. There was an intelligent case to be made for enacting the Human Rights Act to allow individuals that ability to rely in domestic courts, and also to render it less likely, as Joshua says, that the UK would be held in breach of its international obligations. But it's important to see the Human Rights Act as part of a larger matrix of how we protect rights in the UK. To take a kind of bit of a blunt example, think about the right to life. It's not Article 2 that provides the practical expression of that right in our legal system. It's the right to murder. It's all of the other legal regulations that regulate activities that might endanger life. So we have to see the Human Rights Act in that broader picture, I would suggest.
Thank you.
Yes, I mean, I think Joshua's right to say that by bringing rights home, which was the statutory intention of the Human Rights Act, it made access to justice faster and cheaper. And of course, there are lots of other sources of human rights in common law, statutes like the Equality Act, all sorts of legislation contains rights. But I think what the Human Rights Act did, as well as making access to those rights more effective and broadening some of the rights, which go beyond common law, was to make access to the convention rights more transparent and more legitimate. Because those rights, which were known to some expert lawyers and were used to interpret other ambiguous legislation or to explain what the ambit of the common law might be or what the principle of legality meant, were there on the face of a statute that Parliament had chosen to enact. And then the judges who were enacting them, there are differences between common law rights and convention rights. They could do both. They could look at the common law, they could look at the statute, they could look at the convention, they could look at the interactions between them. These are judges who understand the common law tradition. They're close to the context, the British context in which these rights are being applied. And they can do so in a way that's informed but not dictated to by the standards of the European Convention, of the European Court of Human Rights. And consequently, that makes law more accessible, which is, I think, a fundamental aspect of the rule of law.
Thanks very much. Can we turn to Lord Dubbs for our next?
I'm Alf Dubbs, member of the Lords. Bit of echoing still. Can you hear me okay? Right. I want to talk about parliamentary sovereignty. In your view, Has the Human Rights Act had any impact on parliamentary sovereignty beyond that intended by Parliament? Has the Act, its use or interpretation by the courts, served to constrain Parliament in any way? Now, who should we start? Should we start with Joshua on that one, please?
Certainly, yes. The answer is the lawyers can argue that the Human Rights Act is some sort of constitutional statute and somehow harder to amend or repeal. But as you as parliamentarians know very well, the Overseas Operations Service Personnel and Veterans Bill is going through Parliament at the moment. It's in committee stage in the House of Lords. If passed, that would amend the Human Rights Act. It would insert a new section into it, which we can discuss. Two new sections, in fact, one dealing with derogation and the other dealing with time limits. So this simply shows that Parliament remains sovereign, and if Parliament wishes to amend or even repeal the Human Rights Act, it can do so.
Right, thank you. Who would like to go next? Richard, would you like to go next?
Sure. I mean, there's a very simple answer, which is no. And the bad press that sometimes the Human Rights Act gets, that it's sort of judges entering into the realm of politics and overstepping the mark, is constitutionally incoherent. All that courts have been doing is that which Parliament has told them to do, which is to apply the Act. And any argument to the contrary just doesn't make legal sense. Could I just wrap that up slightly, just coming back on that first question as well, just to give that some context, because understanding the Act, I think, has to be seen by way of a long view, as Graham was saying. Courts have always, well, at least for centuries, since the 1760s at least, been very keen to protect fundamental human rights. That's what courts do. That's their job, and it's often protecting them from the executive, and that's what they do. What made the Human Rights Act remarkable is that it gave clear articulation to what those rights were. And that's had a number of effects, one of which Joshua rightly identifies as reducing the amount of times lawyers need to go to Strasbourg. But it's also had a more profound effect, I think, as well, because by clearly articulating what our rights are, it has helped change the culture of rights. I mean, sometimes, as we all know, with a backlash to that, but it's had also an incredibly positive effect, which is clear articulation of my rights. These are my rights. It creates a culture in which people talk about their rights, and they're able to identify what they are when they talk about them. It's meant judges become more conversant, politicians become more conversant, and all of us become more conversant. So sorry, that's a very long way, Lord Dubs, in answering your question.
Can I just chip in on that as well, to say that I just don't understand how it can be said that the Human Rights Act is a constraint on parliamentary sovereignty, because it's a vindication of it. Courts have always applied the principle of legality, which is that the executive won't, well, at least Parliament is presumed to expect the executive to act in compliance with fundamental rights, and it's only if Parliament says in express terms you can do something that's against human rights that the courts will allow them, say then that's what Parliament wants to happen. That's always been the case. The Human Rights Act put that on the statute book and said interpret legislation on the assumption that it's intended to comply with this set of rights, and if you can't, leave it to Parliament. And that's, I think, a bit of a gloss on what Joshua said in opening, that the gays in the military example, if it was in secondary legislation or in a policy and the court said this is contrary to human rights, well, then that would be the law. If it was in primary legislation, the court, under the Human Rights Act, would only be able to say this is contrary to the convention. We can't, therefore, give gay personnel the right to serve in the military, but we can tell you it's contrary to the convention, and over to you now, executive, to decide whether to bring in an order seeking a remedial order, or alternatively for Parliament to legislate. But it's an absolute vindication of parliamentary authority, and it seems to me often when people are saying the judges are taking up too much power or there's some change in the relationship between the three limbs of the Constitution, really what they're talking about is the supervision of the executive and not the power of Parliament, and that's a really important distinction in a in a constitution like ours, where the executive often is the majority in Parliament.
Thank you. Professor Chi.
Well, thank you. It's an important question, and I agree with much with what has been said, although I differ in part. So I certainly agree that the Human Rights Act was designed to be, and in broad term remains, consistent with parliamentary sovereignty, insofar as none of its provisions, as a formal technical legal matter, directly touch upon Parliament's legally unlimited lawmaking capacity. And indeed, some of its provisions implicitly reaffirm that principle, such as Section 4, subsection 6, saying that declarations of incompatibility won't affect the validity of the legislative provision in respect of which that declaration has been issued. And so I agree with Sir Patrick Elias, the former Court of Appeal judge, who said that the basic structure of the Human Rights Act leaves the principle of sovereignty in place, although he added a caveat with which I agree, albeit just. Where my worry does lie, and where I probably disagree with the rest of the panel, is the extent to which the Act could be said to warp the operation of other important constitutional principles, notably the rule of law, by at times introducing via Section 3 substantial uncertainty as to the meaning of legislation, by warping the separation of powers, again, notably through Section 3, by obscuring the distinction between the judicial and legislative function, insofar as Section 3 can be used as a powerful tool of practical law reform, and to some extent the way it could be said to warp democratic self-rule, insofar as the combined effect of Sections 2, 3 and 4 might be said to curb Parliament's ability and indeed a willingness to exercise appropriate political responsibility over controversial questions of public policy. I absolutely agree with the panelists that to the extent that the courts sometimes find themselves in a difficult position of having to make political judgments on controversial matters, in respect of which they might be said to lack the requisite level of institutional competence and legitimacy, to the extent that the courts find themselves in that position, it is by virtue of a policy choice that Parliament made in 1998. So I certainly agree with that.
Thank you.
Can I just follow up, Professor G, on that? Are the issues that you've referred to, the warping that you've described, isn't that a function of the fact that we're a signatory to the European Convention on Human Rights rather than the Human Rights Act? How does the Human Rights Act do this warping in a way that wasn't done before by the European Convention?
Well, it's a good and important question. So there's certainly an intelligent case for why the Human Rights Act was enacted. We mentioned before the bringing rights home and allowing individuals that greater access to justice, and also to render it less likely that the Strasbourg Court would find the UK in breach of its international obligations under the Convention. And some of the saving grace for those who are critics of the Human Rights Act was that its structure was designed to minimize the political role for domestic courts. There's a critique that at times the domestic courts haven't always kept within their lane on some cases, and we might explore some of the aspects of that in the context of Section 2 and Section 3. There's also a concern that is more nebulous, but I think it is important, is in that the Human Rights Act is an important accelerant in a changing judicial culture, not the only one, but an important one nonetheless. That is a changing judicial culture that I think has been alluded to by some of your previous witnesses. And some judges welcome it, but others do view it with regret and alarm. And so I think there, 20 years on, I think is probably enough time just to reflect on where does the Act secure some really good changes? And we've talked about raising public awareness, a changing culture of rights, but are there some reforms that would actually help keep an appropriate separation of powers, which also would help insulate the courts themselves from the dangers of politicization and the criticism and political pushback that can come from that.
Could I just pick you up on the point about the case, if you could give some examples of cases where you feel that the judiciary have not kept in their lane, and those cases which you feel have represented politicisation of the judiciary, such that people might disapprove of it, including, as you suggest, other members of the judiciary. Which cases are you thinking demonstrate that?
As members of this committee will know, but people watching may not, so under Section 2 of the Human Rights Act, the courts are to take into account the case law of the Strasbourg Court. Early in the life of the Act, Lord Bingham articulated the so-called mirror principle, which suggested that the domestic courts would generally follow the case law of Strasbourg. And there was that was much criticised, but there was a rationale for it. It was in line with the Act's goal of trying to decrease the likelihood of the UK being found in breach by Strasbourg, but also it minimised the role for the domestic courts. So they were to follow the interpretation of convention rights favoured by the Strasbourg Court, rather than advancing their own novel creative understandings of convention rights. So at times, the courts, although that mirror principle was articulated by Bingham, one of the ways it's been qualified is by the willingness of some senior judges to move beyond Strasbourg and to advance interpretations of convention rights that go beyond what's in the case law. Examples would include Nicholson, where some senior judges indicated that the ban on assisted suicide was incompatible with the convention, although not required to do so by the Strasbourg case law. The 2018 case from Northern Ireland on the ban on abortion. So there'll be a couple of examples in the context of Section 2, where I think some senior judges went beyond what was appropriate and beyond what was envisaged by the Act as it was originally conceived. I would add that we might agree with the substantive outcomes in those cases. We might not, in the scope to disagree about questions of rights. My concern is whether the means, the courts were adhering appropriately to the constitutional means in those sorts of instances.
Could we, Richard, are you wanting to come in on that?
Yeah, I'm not. I understand what Graham is saying, but I'm not sure I agree with him. These are examples of judges not keeping the lead. I mean, firstly, Section 2 doesn't require domestic courts to always adhere to decisions of Strasbourg. It has to have regard to them, and generally it will for a range of reasons why it will follow what Strasbourg says. But I don't see the cases and the examples that Graham gives as examples of judges keeping out of their lane on the opportunities where they've gone further. I mean, that's entirely consistent with the European Convention being as a human rights instrument, being one that evolves. And it's perfectly proper, I think, and entirely consistent with obligations under the Act. It's entirely consistent with the way that judges approach law here and often in civil law countries, that you take a teleological, purposive approach. You identify, you may be faced with scenarios that the Strasbourg Court has never had to face with, and you ask yourself, well, what's the convention compliant argument? That's all applying absolutely established, uncontroversial tools of judging, completely consistent with the tradition of judging in this country and the way that courts apply law. I really don't see it as an example of judges failing to keep in their lane.
May I add something to that? Because
yes,
Professor G talked about potential problems being breach the rule of law because there might be uncertainty about what legislation meant, and potential problems about separation of powers, the keeping in your lane issue. Now, as regards the rule of law, it is inevitable that there are statutes where there's uncertainty about their meaning, otherwise you wouldn't need judges at all. The issue is where there is that uncertainty, whose view prevails. And our constitution, it was decided in the 17th century, it's the judges, not the Crown, who decide what the law is in a case of uncertainty. It's really important that we keep that. That is the rule of law. Otherwise, it's the rule of might. It's executive power, which is overweening here. And the second question about the separation of powers, I just don't agree that judges think they can or do, in fact, use Section 3 of the Human Rights Act as an instrument of practical law reform, as Professor G puts it. And there's a good example, early example, Ries, a care plan, where there were seen to be problems in the way that devising care packages for looked after children were made, and the I think it's the House of Lords actually before the Supreme Court said we can't. We can see that you need staging posts. This policy doesn't work, but we can't do that because that would be judicial legislation, and we can't do it. So the best we can do is make a declaration of incompatibility, indicate where the problems are, because it is not appropriate or possible for us as judges to put in place practical reform. We can just tell you that what you have here breaches human rights. So I just think the judges are incredibly, in fact, sometimes overly conscious of their constitutional role. And the real problem I think we've faced in the last 5 or 10 years, certainly, is actually executive overreach. And I find it worrying.
Can I just agree with Helen, please? I take Graham's point that some people think that the Supreme Court went too far in Nicklinson. Lord Sumption certainly thinks so. But the most that the 5 judges in the majority felt they could do was to make a declaration of incompatibility. And 3 of the 5 decided they shouldn't even do that. They left this up to Parliament. Now, Graham, I'm sure, thinks that there was a bit of an implied threat that if Parliament didn't intervene on the issue of assisted suicide, well, the judges would. Well, that may be so, but they haven't. And there is a feeling sometimes that the judges are rescuing Parliament because some issues are just too difficult for Parliament to deal with. So I don't think that this is an example of activism. And more broadly, I think that if the Human Rights Act had not been enacted, the judges would be using the common law in exactly the same way. So that's the crucial point. The judges are developing the law. Some are more activists than others, but they always develop the law and they use whatever tools are available to allow them to do that.
Thank you, Joshua. Can I pick up, Professor Gee, on your question about uncertainty? Because if there's uncertainty until the UK courts have decided something, why is that any worse than uncertainty waiting until a Strasbourg court has decided it? Isn't the uncertainty even worse if you have to wait and have a set of European judges decide what the law is and what is or is not a breach of the European Convention in terms of action within the UK? Why does pushing that back out again to Europe make it less uncertain? It seems to me, on the face of it, that it would make it more uncertain.
Excuse me. Well, there is a lot of uncertainty. That is a part of the problem. So there is often significant uncertainty about the meaning and effect of convention rights. The structure of the Human Rights Act to some degree compounds that uncertainty. So, for example, Section 3, there'll be uncertainty about whether a rights compatible reading is possible of the legislative provision that's before the court. And then in turn, whether there'll be uncertainty about what such an interpretation might be. All of this, to my mind, does compromise legal certainty and the rule of law. And so that's why I disagree with Helen Mountfield when she mentions Ries, which I think was a case where the courts approached Section 3 in a more prudent fashion. But there are cases where the courts have been much more expansive in their use of Section 3 and in ways that have increased uncertainty by upending policy choices made by Parliament. So the examples that spring to mind would be the 2001 case of RNA, where a majority of the law lords used Section 3 to, when they were interpreting Section 41 of the Youth Justice and Criminal Evidence Act 1999. Section 41 had provided in rape cases that in almost all cases, evidence relating to the prior sexual history of a complainant, the rape victim, would be excluded. The courts used Section 3 to, they found that it was possible to arrive at a convention-compatible interpretation that said that such evidence would be admissible in effect wherever required to vindicate the Article 6 right to fair trial. That upended Parliament's policy choice in a way that was very surprising, not consistent with legal certainty, and at odds with our traditional canons of statutory construction.
Couldn't that have been done by the European Court anyway?
So, I mean, there is, so part of the argument I was making previously was that one way to insulate our courts, our domestic courts, from too much criticism is to encourage them to follow the line of the Strasbourg case law in line with the mirror principle, and to try and manage the levels of uncertainty so far as possible, recognizing that when you have an international treaty dealing with general abstractions about rights, there is going to be an unusually high level of uncertainty. So Helen Mountfield is certainly right when she says that uncertainty is an inherent part of any time you try to draft a legal rule. But many people observe that there is an unusually high degree of uncertainty in any statutory Bill of Rights and in a statutory Bill of Rights, which is overseen by an international court that has that living instrument interpretive approach that Richard Hermer mentioned earlier.
Thank you. By the way, I'm hoping that we're going to deal with the problems in section 41 of the Youth Justice and Criminal Evidence in the police bill, which is currently before the House. Could we turn to our next question from Baroness Massey?
Thank you, Harriet. I'm Doreen Massey. I'm a Labour peer. Question 6 is mine. The independent review asks whether any changes are required to how courts and tribunals have dealt with provisions of subordinate legislation that are incompatible with convention rights. Do you consider that the current system is problematic? What would be the advantages and disadvantages of any changes? Can I start with Helen if she's willing?
Yes. Well, again, I don't see any problem with this. It seems to me that this is a vindication of parliamentary authority. Parliament has said we put on a statutory footing the presumption that already existed that all law should be interpreted in a rights-compatible way. And it's only if Parliament says, we know these are the international obligations and we still want to legislate in this way, that the courts don't have a role because Parliament's the ultimate determiner of the law. When Parliament gives the executive effectively power to put forward subordinate legislation with the idea of saving parliamentary time by the shape being put forward by Parliament and the subsequent rules having a lesser degree of scrutiny, it has done that on the assumption, and the express assumption again in the Human Rights Act, that those rules will comply with convention rights, and if they don't, then they are not within the authority that Parliament gave the rulemaker to put the rules forward. So it makes perfect sense to say those rules then should simply be disapplied. And that's something that we can all understand. Again, as Professor G says, there's always the question of what do rules mean, and sometimes that can create problems for anyone who's trying to apply rules. Do we know what these rules mean? But that strikes me as constitutionally unproblematic, and I'm not really aware of any cases where it's created a practical problem.
Thank you. Anyone else like to come in on that? Richard, you have your hand up.
I'm just going to say, I mean, I agree with Helen. The position long before the Human Rights Act was that courts applying something called the principle of legal certainty would look at subordinate legislation whose effect was to infringe with human rights and ask itself whether or not that had actually been sanctioned by Parliament through primary legislation. And if it wasn't express in primary legislation that the rights were to be infringed, the subordinate legislation would be deemed unlawful, be deemed ultra vires. So there's nothing remarkable at all in courts reviewing it. And under the Human Rights Act, as you all know as parliamentarians, by section 19, when a bill comes up for a second reading, the Minister of the Crown has to provide a statement saying that the bill is compatible with the convention. So the idea that subordinate legislation will be reviewed to see if it does that which Parliament intended that does is I think, utterly unremarkable.
Thank you. Joshua Graham. Joshua, you have your hand up.
Thank you. Certainly, I'm not aware of any problems with the way in which courts and tribunals deal with subordinate legislation. But I was trying to work out what was behind this question, what is behind the question from the independent review. And you saw last week the government's response to what you might see as a parallel inquiry, the Independent Review of Administrative Law, chaired by Lord Folkes. And the government is considering either a presumption that remedies will be prospective only in relation to statutory instruments, or even a requirement that remedies in such cases should be prospective only unless there's an exceptional public interest requiring a different approach. Now, the advantage of that, from the government's point of view, is that secondary legislation that people had previously relied on would not be overturned. The disadvantage from the claimant's view is, as the government seems to accept, the successful claimant wouldn't get any benefit from winning the case. And it occurs to me that this may inform the government's thinking about the Human Rights Act, that it wants to at least consider changing the remedies that are available under a successful Human Rights Act claim in line with its proposals for judicial review. It looks to me as if the government must be planning a bill in the autumn on both judicial review and human rights, because I think the two issues are very closely connected.
Thank you. Graham, do you want to add anything?
Well, briefly. So sometimes litigation under the Human Rights Act aims at secondary legislation, and as we've heard, the courts are able, under the Act, to quash it if it finds a rights incompatibility. And we've heard many defend this on the grounds that it doesn't constitute an undue interference with executive lawmaking. Those arguments tend to rest on two main limbs. So secondary legislation is subject only to limited light touch parliamentary scrutiny, so any scrutiny that the courts can provide through judicial review is welcome. And then the second point, which we've heard, I think, this afternoon, is that courts only very infrequently will actually quash delegated legislation. And in this respect, I'd commend to the committee a blog post by Dr. Joe Tomlinson and others last month, published on the UK Constitutional Law Association website. They pointed to a 7-year period between 2014 and 2020, where they found only 14 pieces of delegated legislation that were quashed under the Act. This is obviously low, both in absolute numbers, but especially when you take into account the thousands of statutory instruments made each year. So I too am untroubled for the most part by this, but I think by this part of the operation of the Human Rights Act, for completeness, and I think I should note that there are some critics of the Act who point to the importance of legal certainty in the context of secondary legislation as well as primary legislation. Some critics are concerned that the courts seem a bit too quick at times to undercut secondary legislation without paying sufficiently close and careful attention to the terms of the empowering statute to see whether they're convention compatible. And so that's led critics like Professor Richard Eakins at Oxford University and the Judicial Power Project, writing with John Larkin, the former Attorney General for Northern Ireland. They have submitted evidence to the independent review arguing for a change to the Human Rights Act. So they have proposed revising Section 21's definition of primary legislation to be legislation so as to encompass delegated legislation, so as to immunize it from the possibility of being quashed. Or alternatively, they have proposed that something akin to a Section 4 declaration of incompatibility should apply to delegated legislation as well as primary legislation. So for completeness, I think it's important to note there are critics who are proposing those sorts of reforms.
Okay, thank you, everybody.
Can I just go back to Joshua on your very interesting speculation that it might be that what the government are hoping to do is to do something similar to what they're hoping to do in relation to the judicial review. If they do that in relation to the Human Rights Act, i.e. just make it a remedy, no longer a remedy for past breach, but just about prospective action, what impact would that have in terms of the workings of the Act and enforcement of human rights in practice?
It picks up the point that Graham G has just made, which is that people rely on secondary legislation, and if it's overturned, if it's declared void rather than voidable, then this is disruptive, it needs putting right, people's rights need rearranging, all sorts of things go wrong. And that's the thinking behind not only saying that the remedies should apply in the future, but that there should be a presumption that they should apply in the future, or maybe even a requirement. So in one sense, it would make things very orderly, but in another sense, people who win their cases simply wouldn't get any benefits from so doing. They would have the warm feeling that they had persuaded the government to change the law, except, of course, the government wouldn't have to change the law if it can persuade Parliament to rewrite the law in some way that enables it to do what it wanted to do. So, what the government is seeking to do would undermine, or at least is proposing to put out for consultation, would undermine the existing benefits of judicial review. And presumably, if they can apply that to the way in which the Human Rights Act deals with subordinate legislation, that would apply in that case too.
So would that have, in your view, a big effect on whether people would take cases if they couldn't get the remedy that they wanted and that was motivating them to take the action, if they were only wanting to put something back to Parliament again for the future consideration? What would be the point of them going to court with a Human Rights Act claim in those circumstances?
Good question. I mean, campaign groups would no doubt want to draw attention to errors in the law, and there's a public interest in getting the law right and getting the law to say what it means and do what it says. So there is some advantage in that, and of course the government may well accept that it had taken the wrong approach in the past and agree with the campaign groups that bring cases and say it should go in a different direction in the future. So it's not a complete waste of time. People say, of course, they're not in it for the money. They're not seeking to get compensation. They wouldn't get compensation anyway. They're simply trying to put things right. So there would still be challenges, but it would be much easier for the government if it didn't have to take judicial review cases, pay compensation to people who've been wrongly deprived of some benefit for many years in the past.
But in relation to the Human Rights Act, if they were going to do that with the Human Rights Act, wouldn't people in those situations simply then end up going to Strasbourg again, like they did before the Human Rights Act, in order to get their breach of rights recognised with compensation and whatever action?
It depends whether the government, in putting the law right, actually enabled people to enforce their rights or not. Certainly, if the government, in regularizing the law, put itself in breach of the Human Rights Convention, then people would take it to Strasbourg. But it might be possible to find a way of rewriting a statutory instrument, secondary legislation, compatibly with the Human Rights Convention, I suppose.
Thank you. Can we turn to Sarah Ludford, Baroness Ludford, for the next question?
Thank you, Chair. To some extent, the subject of this question has been discussed in other questions, but what I wanted to ask is, do you think the Human Rights Act strikes the right balance between enabling individuals to enforce their rights and effective government? I mean, the government may find it inconvenient, but do you think, in your professional opinion, that the Act interferes with effectiveness of government?
Can I just answer very briefly on that one? I don't see the two as alternatives. I think if we're governed effectively, then individuals can enforce their rights. And if they can't enforce their rights, then something must be wrong with the way we're governed.
Anyone else? Richard Turner, would you like to come in?
Yeah, no, I was just agreeing. I was agreeing with Joshua. I mean, I've no doubt that being forced to comply with legal obligations has been an occasionally irritating and burdensome annoyance for governments for centuries. But I'm not sure that the Human Rights Act itself has altered the balance. And the Human Rights Act itself has made legitimate governance more difficult or less effective. I've certainly, in my experience, can't think of a single case in which that's the case, and in which one couldn't turn around and say, well, that's the price of the rule of law.
Professor G?
Well, thanks. I mean, I agree with Joshua and how he summarises effective government. I think I disagree with Richard on the balancing point. It's certainly the case that an effective system of constitutional government requires appropriate relationships, balanced relationships between judges, ministers, and parliamentarians. And I think there's a reasonable argument that the Act has contributed to the unbalancing of those relationships, not the only driver, but an important one. And here I think it's important to acknowledge the extent to which the Act changes, and some critics would say subverts, the type of reasoning required of our domestic courts. So that reasoning today extends to questions about how to understand convention rights, how the sometimes vague and opaque, critics would say unprincipled and poorly reasoned case law of Strasbourg is to be brought to bear in a concrete case, whether particular legislative or executive actions amount to a proportionate limitation on a general interest, whether legislation is compatible with convention rights, and if not, to declare it out of line. That does strike me as changing the relationships between our key institutional actors. Some will welcome those changes, others won't. I note that most judges do acknowledge that the Human Rights Act has increased their role on the constitutional stage. And again, people will have differing views on whether that's a good or appropriate thing. What I would be keen to emphasize is that the rule of law is a vital ingredient for effective government. Yet I think there is a case to be made that the Human Rights Act compromises the rule of law in a number of important ways, which I don't expect my fellow panelists to agree with. But it does so by introducing into domestic law convention rights, which are framed, in my view, with a greater degree of uncertainty than we see in much ordinary law. It does so by heightening this case law of the Strasbourg Court, which is informed by that living instrument approach to interpretation, which licenses the Strasbourg judges to rewrite the terms of the ECHR beyond that which was agreed by the signatories. And so the content of law, the content of the rights themselves then rests on a changeable body of case law that is rife with judicial decisions about matters that are highly political in nature, arguably not the proper subject of judicial decision, including on matters that were previously deemed non-justiciable in our constitutional tradition. That is to say, not subject to a judicial decision because it's not possible to apply legal principles to them in an intelligent fashion. All of this, critics would say, undermines effective government.
Helen, would you like to?
Sorry, Baroness Ludford.
I'm just inviting Helen Mountfield to come in on this question.
Yes, thank you. Well, I think in agreement with everyone, it's very important to appreciate that effective government is government to which the rights given to people by Parliament or by the common law can be vindicated. Effective government isn't absolute government. In my view, in a democracy governed by the rule of law. And it is right to say that the process of reasoning that's been introduced by the Human Rights Act in terms of some rights and the use of the concept of proportionality has extended in some ways and broadened the way that judges look at whether a public body is acting within its powers. But bearing in mind that before the Human Rights Act, the standard that was used was unreasonableness. Have you taken into account all relevant considerations? Who decides what's relevant? This is always an art. And in a sense, what the proportionality standard has done is, again, make it more transparent, set out the process of judicial reasoning in a way that people can see. And people like Lord Sumption actually himself have said the difference between the concept of Wednesbury unreasonableness, irrationality in law and proportionality isn't so different. It's just a question of saying what are the factors that you take into account here? How far is that something for the judge to decide? How far is it something for the decision maker? It is a constitutional conversation, and the fiction that pre-Human Rights Act, the law was maths, and it was all very easy. Parliament said what the law was, and then there was nothing for judges to do. It's just not true. I think what the Human Rights Act has done is enable people to articulate their rights and make the law more accessible, and that's a good thing for effective government and for individual rights. I don't think there's an opposition between them.
Thank you. I must say, listening to what you've been saying, Professor Gee, and remembering that I was a minister in the cabinet before the Human Rights Act making decisions, and also a minister in the cabinet after the Human Rights Act making decisions, I don't remember any sense that there were suddenly incursions from the judiciary on us and that we couldn't govern in the way that we felt right and was supported by Parliament. But I do feel that there was more transparency, as Helen Mountfield has said, about the process of decision-making in terms of its compliance with the European Convention. So having been one of those people, I didn't have that sense that suddenly the wings were clipped and we were suddenly knuckling under to judicial adventurism. But bearing in mind I'm supposed to be chairing this committee rather than giving evidence to it, I think perhaps I better move on to, Richard, you want to
I was
speak?
just going to follow up, if I may, from that, because I think one of the many positives of the Human Rights Act is the requirement that Parliament has placed on the executive, that when the executive seeks to bring legislation before Parliament, thought has been given to its compliance with human rights, that builds in human rights, and that is effective government, not just good government, it is effective government. And that ministers, and indeed all levels of government, that ministers have to have regard to human rights when they're making decisions, because Parliament has told them that's what they have to do. And again, I don't think that's just good government, I think that is effective government.
But we would have had to be doing that anyway before, or at least we should have been, because otherwise we'd end up in the European Court with findings against us. So in a way, it protected us.
Yes, you also had the kind of the general public law duties. You always, people were told you have the judge looking over your shoulder, and that was a good thing for decision makers because it promoted good and effective government. I think the Human Rights Act, as Helen said, helps kind of codify that because it articulates the rights that have the thought process that has to be gone through. And again, I think that is not just about good government. It's not just about promotion of human rights. It's effective government, because governments that comply with human rights tend to be effective governments.
Thank you. Can we move on to Baroness Massey for the next question?
Yes, thank you, Harriet. Do you think that the requirement under Section 2 of the Human Rights Act to take into account European Court of Human Rights jurisprudence made it easier for individuals to enforce their rights in the domestic courts? Richard, would you like to start on that?
Yes, I think it makes it clearer. I think it helps identify the target. It also serves one of the fundamental aims of the Act, which is bringing the rights back home, funnily enough, because if we fail to give effect to Strasbourg decisions, then people would be going off to Strasbourg to enforce their rights, even though they've been dealt with by the domestic courts. So, and as I think, as Graham touched on earlier, although the principle is that you will have regard to, and often close regard to, Strasbourg's rights, that hasn't prevented the courts here from taking their own views in clearly defined circumstances.
Thank you. Graham, would you like to come in?
Thank you, Baroness Massey. I think I've touched on Section 2 already, but if I may, before I get to your question, I would like to just pick up that conversation at the end there on the prior question, because I think there was a really important points there. I mean, parliamentary and judicial scrutiny of executive action is indeed essential for the rule of law and effective government. And I would not, I'm a constitutional lawyer, I would not depart from that. But I do think it's important for us to acknowledge that there is room for a good faith disagreement about where we draw the lines. And particularly, for this committee, when, thinking about the balance of evidence that you received so far, just to be aware that there is that good faith disagreement. And the sort of critique that I am trying to offer today to inform your committee has a very long lineage that transcends or traverses the political spectrum. So this idea that there's a belief in the existence and persistence of moral disagreement over rights is to be found on both the left and the right. And that shapes the sort of institutional apparatus that, people think about, what is the best way to protect rights? We all want to protect rights. We probably disagree about which rights, what weight to play on them, how they should relate to each other, and ultimately what is the appropriate conditions in which to limit rights and who should have the say in determining whether that's right or wrong. So we're all agreed, we're on the same broad enterprise, we're just disagreeing about how to do it. And I would also agree that there are parts of the Human Rights Act that, I think are very positive. So Section 19 ministerial statements, I can well believe, have had an important role in raising awareness of rights inside the executive, making, very officials briefing ministers in a very careful way. The role of this committee in raising rights awareness, and you've already heard from other public authorities about the way that the Human Rights Act has raised awareness. I don't think that should make us think that the Human Rights Act is a static statute that is not possible of being improved. I'm making a set of arguments to improve it in one way. People might want to argue for it to be spruced up to make it an even more powerful statutory Bill of Rights. Apologies, Baroness Massey. Returning to your question, so I think I've already suggested that there's a couple of reasons to be concerned about Section 2. One is where judges in our domestic courts seem to have gone beyond the Strasbourg court and to offer their own novel understandings of how to interpret convention rights. A second concern is how the Strasbourg court itself interprets convention rights. Focusing on Section 2, I know there are some people who will say that the courts have self-corrected over the course of the last 20 years on how they approach Section 2. Self-correcting can always be uncorrected, so I don't think that in itself is removes the need to consider whether to reform Section 2. One option would be to repeal Section 2, but this would amount to de facto authorising domestic courts to decide freely how to receive Strasbourg case law into domestic law and how they should approach the interpretation of convention rights. A better approach might be to amend Section 2 to make it clearer that the courts can have regard to the Strasbourg case law, but subject to the proviso that they should be interpreting those convention rights within the terms of the ECHR, understood as an international treaty rather than as a living instrument.
Thank you. Helen, do you want to say anything?
Yes, I mean, if that were to be the case, then we would ignore Strasbourg judgments on issues like, I don't know, use the internet, the Big Brother watch, or all sorts of things that have arisen since the 1950s. And so we would say, well, we will only take on interpretations that would have passed muster in 1949. Anything that's happened since 1949 is irrelevant so far as British judges are concerned. But what I'm curious about is that Section 2 is so very clear that you can take these judgments into account. You are not bound by them. And that, I think that's just about as clear as it can be. And there was a recent-ish judgment, I'm going to forget the name of the case. It was a firm of solicitors that was trying to get legal aid for taking cases to Strasbourg. And the judge, Mr. Justice Kerr, said, you can't, because Strasbourg is not part of the UK, the England and Wales legal system, which is what the legal aid system was set up to do. Convention rights in the Human Rights Act are the rights as they apply in the UK. And so you can get legal aid for these cases in the UK courts. And how the Strasbourg principles that apply to all the member states apply to our specific system is ultimately something where, of course, the judges have to say, we look at the general conspectus of convention law as interpreted by the Strasbourg court about what these principles mean. But here we have the British criminal justice system. How does it apply here? What does the presumption of innocence mean here? Can you use hearsay evidence even if the only live witness has been killed here? And that seems to me inevitable, that our judges would, of course, look at what the Strasbourg court said when they were trying to decide what convention rights in precisely the same language meant in British law, but they would not regard themselves as bound by it, and they don't at the moment. And the Human Rights Act makes it totally clear they don't have to either.
Thank you. Josh,
yeah, I just want to endorse what Helen says. I think she was referring to a case called Horncastle, a judgment from the Supreme Court at the end of 2009, which was about the admission of evidence in a criminal trial from a witness or witnesses who were not available for cross-examination. The appellant, the convicted criminal, relied on a Strasbourg decision called Al-Khawaja, but the Supreme Court said that Strasbourg had got it wrong. And that case, I noticed, is cited in a submission to the independent review by the Society of Conservative Lawyers. They support the outcome of that. And the point that that case makes is that the British judges must take into account decisions of the Strasbourg court, but they don't have to follow them. And if they think Strasbourg has got it wrong or has misunderstood how our system works or something like that, then they can say so. And Strasbourg often backs down and says, yes, you were right, we were wrong, we didn't really understand, and decides the next case differently. So I don't think there's a problem. I don't think that must in subsection 1 of section 2 of the Act needs to be amended to read may.
Thank you, everybody.
Thank you. Could we turn to Lord Henley for our next question?
Hello, I have got my volume. Oh, good, yes. Oliver Henley, Conservative member of the House of Lords. I just want to come in from the other point of view, and that is, do you think seeing the reasoning of the UK courts in human rights cases helps the European Court of Human Rights to understand our own laws? And does this have an impact on the likelihood of an adverse finding against the UK? And perhaps if the practitioners could start first and then move on, so either Richard or Helen.
I think on the basis I'm not on mute and Helen is, so that saves 10 seconds. I think it undoubtedly helps the Strasbourg Court for the reasons that Joshua really was just giving, because it gives a reasoned analysis as to the position here, and that is always going to help Strasbourg, and inevitably does. And I think absent that, the United Kingdom is likely to find itself in more protracted, more complicated litigation for the Strasbourg courts, and also more likely to lose.
Does Helen want to come in?
Yes, I mean, and I think the reasoning in the British cases does often help Strasbourg say, actually, we've changed our mind. So there was a case on self-incrimination involving Ernest Saunders, where the Strasbourg court said evidence couldn't be used because it was self-incriminatory. The British courts didn't like it. Lord Bingham said he didn't understand it. Lord Staines said it was wrongly decided. And next time a case about self-incrimination came to the Strasbourg court, which was about road traffic offenders, they said, no, we were wrong. We now understand the position, having read the reasoning in the British cases, and we change our mind on that because we just didn't understand enough about the British system. So there's actually a really intelligent and useful constitutional dialogue where I think European judges get to understand the British legal system more, and they have the benefit of the kind of really close reasoning that happens in our domestic courts. Even if a case does go to Strasbourg, they see where the British judges are coming from in their reasoning. So I think that is the reason why, as Joshua said, we have the British government, that have a disproportionately high success rate when cases do go to Strasbourg, because things have been ironed out in our own courts first.
Yeah. Professor G, or?
Well, I mean, can I jump in here? So, I mean, an example along similar lines would be a relatively recent case of Hutchison and the UK, where Strasbourg revisited the UK's life sentencing regime, and in so doing reversed its earlier decision in Vinter. In so doing, it was influenced in part by the reasoning of the Court of Appeal in a case called McLaughlin. And in McLaughlin, the Court of Appeal had held that Vinter had in fact misunderstood part of the Crime Sentences Act 1997 and the manual that oversees life sentences. So that's a useful way that, yes, reasoning of the domestic courts can help to shape the Strasbourg's understanding of the complexities of domestic law. Whether that amounts to anything that we can meaningfully describe as a dialogue, I think is a bit more dubious, remembering that the Strasbourg Court is an international court overseeing a treaty with upwards of 50 contracting parties. And so can you really be in a meaningful discussion, dialogue with top courts and all of those different contracting parties? One of the reasons why I mentioned Hutchison is because there's a question I think we'd want to reflect on, whether that was an example of an intrajudicial dialogue, or, as one of the dissenting judges in the Strasbourg Court hinted at in Hutchison, whether that was an example of the Strasbourg Court taking into account the political sensitivities in the UK on the back of the prisoner votes saga, the criticism of the Strasbourg Court by some ministers in recent years, and also in the shadow of Brexit. So one of the judges on that Hutchison case in the Strasbourg Court issued a withering dissent when he spoke about this decision actually being owed to the current political environment. And he was worried about the systematic implications of that sort of approach. What that example does show is the political character of the Strasbourg Court. So some might want to laud the fact that there was the court responding to some political sensitivity and showing some political acumen in reversing its approach to life sentencing. But I think we would be concerned if our domestic courts were to be taking into account political considerations in such a fashion.
Thank you.
Shall I chip in on that? I think I agree with Graham that the Strasbourg Court is politically sensitive and possibly more sensitive than a court would be in the United Kingdom. But I think the answer to that is that a court in the United Kingdom doesn't have to follow a decision from Strasbourg, it only has to take it into account. Another example that you will remember from when Lady Hale gave evidence to your committee a few weeks ago was the Animal Defenders International case about paid political advertising on television, whereas, as she said to you, Lord Bingham's opinion in the House of Lords was clearly influential on this knife-edge decision in favour of the British government by the Strasbourg Court.
Thank you very much.
Thank you. Can we go to Lord Brabazon for the next question?
Yes, thank you, Chair. I'm Lord Brabazon, Conservative member of the House of Lords. Given that we're looking into the review of the Human Rights Act, are there any reforms of the Act that any of you would like to see, either within the review's terms of reference or indeed otherwise? Perhaps we could start with Professor Gee.
Thank you for that question. So I think I've already suggested some reforms on Section 2. We haven't, I don't think, discussed Section 3. So
could you try and be sort of, imagine you were not so much drafting the legislation, but be very programmatic about what you're saying, very practical, rather than just saying in the ambit of Section 2. What would be the specific things?
Well, I think I suggested in Section 2 trying to add some wording that would encourage the courts to take into account Strasbourg case law, that it has a very close relationship with the terms used in the terms of the convention itself. In Section 3, I think there's an argument.
Sorry, you've lost me there. Can you just explain that again? I just am not clear what you're saying.
So, in the discussion in Section 2, I think I expressed two concerns. So one would be that from time to time, some senior judges in our domestic courts have seemed to be willing to go beyond the Strasbourg case law. And I think to the extent that that concerns me and it doesn't concern others, there could be an argument to amend Section 2 to provide some sort of direction that the court should not go beyond the Strasbourg case law in developing some novel understanding of a convention right. Now, if you don't accept that premise, that this is a concern, then you presumably wouldn't want to amend Section 2 in those terms. The other concern would be to try to think about how to address the living instruments interpretive approach, which critics find concerning because it licenses, on our view, judicial lawmaking that goes beyond the terms of the convention itself. And so some sort of language that talks about courts having regard to the Strasbourg case law, but subject to the proviso that convention rights should be interpreted consistently with the language used in the terms of the convention itself.
Can I chip in on this one?
Please, yes.
Sorry, Graham, had you finished? I thought you had, but I just wanted to check.
Yep.
Wasn't cutting across you. Because I had thought, and indeed put my name to the Oxford Public Lawyers submission to the independent review, saying that he didn't think that they needed any changes to the Human Rights Act. But I've read the Bar Council response, and in paragraphs 97 and following, they put in what I think is a very productive suggestion, which is that when a declaration of incompatibility has been made and a remedial order is put before Parliament by the executive, Parliament has the choice either of saying, yes, we'll have that remedial order, or no, we don't like your remedial order, and then they can't do anything unless they can bring forward primary legislation. And given that the objective is to have parliamentary scrutiny of what legislation there is to promote human rights, I think there's a lot to be said for the Bar Council's suggestion that when an order is put before Parliament under Section 10 of the Human Rights Act, Parliament has not only the option to say yes or no, but to propose amendments, so that that is the occasion when remedial legislation can be made with a higher degree of parliamentary input. And that is a small, but I think useful.
Did they give any example of where that would have been better had that been the case?
I can't immediately, but there have only been 43 declarations of incompatibility in the 21 years nearly since the Human Rights Act has been in force. And yeah.
So I've heard obviously that argument made before, but it's without as an example of where it's given the Parliament a problem. It's hard to see that it's justified. Might be intellectually justified, but if in practice it's not a problem.
I can't immediately think of one. If I do, I'll write in and let you know. But I can't immediately think of one. But I did think actually, if what we're talking about is a concern that Parliament's role has somehow been taken away by the judges, then that's a good way of putting it back and saying, and if there's a problem, it's not just a chat between the executive and the judges. It's Parliament has a proper role in it, or a stronger role. I just saw the intellectual force of it.
Thank you. Anybody else have any ideas or forms?
Yes, if I may. I hesitate to. I'm very much against the idea of an originalist approach, which is what I think Graham G is calling for. Go back to the wording of the convention. On the other hand, I was talking to Judge Eicher, who's the British judge at Strasbourg, on Law in Action, which you, Chair, very kindly mentioned at the beginning. And he tells us that the court is considering what to do about attempts to make climate change come within the provision of the convention, which of course is something that wasn't mentioned when the convention was drafted 70 years ago. People are bringing challenges under Article 2, right to life, Article 8, right to respect for a person's private and family life, and we'll see what the Strasbourg court does on this. I think there will be critics if the Strasbourg court reads into those articles rather more than was ever imagined by the people who drafted those particular provisions. On the other hand, you can see that these are important issues and the courts may well need to provide remedies. The other point I wanted to refer to was Section 3 of the Human Rights Act. This is the interpretation of legislation so far as it is possible to do so. Primary and subordinate legislation must be given effect in a way that is compatible with convention rights. There's another blog on the UK Constitutional Law Association website published today, It's about analysis of how Section 3 is applied in practice. It's by two young lawyers at the human rights organization Justice. They say it's a well-crafted interpretative tool that is rarely relied on by the courts, but when it is used, the courts have done so to protect rights in a way that maintains separation of the power. They identified only 34 cases where Section 3 was used by going through the law reports, and they said that in many of those cases, the courts simply used it to deal with technicalities and legislative wording, to bring certain factual circumstances within the ambit of a statute which might not have otherwise have been provided for. For example, a parental order in respect of a child born following a surrogacy agreement when the biological father had unexpectedly died. And so unexpected circumstances, the courts have used Section 3 to apply the legislation in the way that Parliament presumably intended. So I think that the concerns that have been expressed about the Human Rights Act needing thorough reform are perhaps overstated.
So I just come in on Lord Brabazon's question, one with a general point and then something just picking up a point in particular. On the general point, I entirely agree with Graham that actually having a review of any piece of legislation is a good thing. Talking about rights is a great thing and can be absolutely done with people with different views in a completely respectful way. But stepping back, my fear about playing around with acts is if it ain't broke, don't fix it, because you start playing around with things, it has all sorts of unintended consequences. And in the context of an act of the import of the Human Rights Act, that has some real dangers. That's my general point. I'd have a very particular concern about one of the proposals that Graham moots, which is that somehow we enshrine the convention as fixed at the time of drafting, and not to be moved without the say-so of express say-so of the Grand Chamber. I mean, that's just not how human rights instruments work. You see all the sorts of difficulties you get into when you have that school of thought applied to the American Constitution. But it's not how human rights instruments work. They change as societies change, as human rights issues change, and they become defunct if they can't do that.
Thank you. Can we go to Lord Dubs for the next question?
All right. Thank you very much. We've touched on this a little bit, but the question is this. Previous governments have established reviews of the Human Rights Act, which have not led to credible proposals for reform. Do you think a further review is necessary at this point? Is there any reason to think it will lead to reform this time? Can we start with Joshua, please?
I don't think it's necessary, but I do think there is reason to believe that it will lead to reform, because I think that the government has committed itself to reforming the administrative law more broadly in terms of judicial review. Its proposals last week, a very quick response time, 6 weeks, and presumably it will push ahead with legislation in line with the proposals it put out. And I would have thought that the government is equally determined to legislate on human rights.
Graham, would you like to have a go at this one, please? Graham?
Well, thank you for the question, Lord Dobbs. So yes, I agree that 20 years on, I think it is timely to have a comprehensive review of the Human Rights Act. One, I think, can quibble with some of the terms of references of the earlier reviews and whether they were designed in a way to really allow a constructive conclusion from the efforts that were undertaken. I think it's important to acknowledge that there has been concern about the Human Rights Act since its introduction, with one major party, which is now in power, having a critique to offer of the Act since its enactment. And I don't think it's helpful for those who are supporters of the Act to deny that political fact.
Okay, thank you very much.
I think that the reason there's been an attack on the Human Rights Act is the same. Is part of the E word, the attack on Europe in general. And we don't, even those who've attacked the Human Rights Act because it has European Convention in its name, don't need to worry anymore. Brexit's happened, and we don't need a reason not to be in the EU. These are rights which we could perfectly easily, and perhaps in retrospect might have been politically better, just to list as rights and say, here they are. But I'm with Lord Bingham. Which one of these rights do we not want to have? What's wrong with any one of the rights? And we can talk about how they get interpreted in individual cases and whether we agree or disagree. But these are rights that every human being would want for themselves or for their family. And particularly when we have faced a global pandemic, it really does bring home to us we have some fundamental human needs and frailties, and they ought to be protected equally. And it's a statement. And I think the problem with the Human Rights Act was that it was very quickly attacked by sections of the press who didn't like some of the people who used the Act. And it made good stories to say, look at this dreadful person who's arguing that, he has a human right to get pornography in prison or something, completely omitting to note that that sort of claim almost never succeeded. And the fact that these are rights that apply to everyone. They apply to children. They apply to people in care homes. They apply to us all. And it's very important, I think, that we argue for these as universal human entitlements. And there was an Amnesty survey recently, opinion poll, which said I think 69% of people thought you needed these rights as a backstop. And I think we just need to make the case for universal rights and fair access to the law for everybody, which doesn't mean to say that bad people get the same rights as good people. They don't. There are limits on people's rights to protect other people. But let's have that conversation within a framework of equal dignity and respect before the law.
I agree entirely, but they're not just universal rights. These are British values. I know it's popular at the moment to have Zoom calls with Union Jacks behind you, but there is an important point to make here. I mean, these articles reflect centuries of common law tradition. I mean, this country was outlawing the use of evidence from torture centuries before our continental counterparts. The rights to a fair trial are deeply ingrained in our common law. It was conservative politicians at the close of the Second World War who were at the forefront of trying to promote the convention because they represented our values. And we should never lose sight of that.
Thank you.
Thank you. Shall we go for our next question to Joanna Cherry?
Thank you very much, Chair. Joanna Cherry, Scottish National Party Member of Parliament for Edinburgh South West. I'd like to ask about what the review's question about designated derogation orders. The review asks what remedies should be available to the domestic courts when considering challenges to designated derogation orders. And I wondered, is this an issue that's caused any problems to date? And what would be the effect of limiting the court's ability to grant relief in respect of any such challenge? Maybe I could start with Graham. Thanks.
Thanks for that question. So I should begin by saying that I'm not an expert on derogation orders. I'm not a public international lawyer, and I know that Richard Hermer, is a very experienced professional in that area. So Section 14, provides the domestic legal framework for derogation. That's the provision that provides expression for the UK's right under Article 15 to derogate in times of emergency. My understanding is that in practice, the Act has shaped significantly how derogation works in practice. It's created the scope for domestic courts to review derogation and presumably also to arrive at a decision about validity that might differ from what a Strasbourg court could do. And we have seen examples of that, like in the Belmarsh case about indefinite detention for international terrorist suspects after 2001, where the Law Lords did quash a derogation order for discriminating between nationals and non-nationals. I don't have a view on this myself, but I am aware that there are critics of the Human Rights Act who argue that the Act should be amended to limit the scope for such challenges. Those critics assume that other challenges to future derogation orders are likely. So again, Eakins and Larkin have made such an argument. They have suggested amending section 6, subsection 3, which would provide that a derogation order should not be treated as a decision of a public authority. They've alternatively proposed that section 21 should be revised so that it includes, in its definition of legislation, so that it includes derogation orders, which would immunize them from the possibility of being declared incompatible under section 4. They recognise, of course, that derogation orders could still be challenged by way of ordinary judicial review. And so they've also called for the Human Rights Act to be amended to include an ouster clause, which would say that it's for the minister to determine whether the Article 15 threshold has been met. That would be controversial and would also likely to be tested in the courts. So I hope that sketched out some of what some critics are saying.
That's very useful, thank you. Perhaps I could turn to Richard on this one.
Well, I agree with Graham's overview. I think the committee should be deeply concerned by any suggestion of ouster clauses when it comes to the court's ability to review fundamental rights, let alone to review a derogation and the basis of derogation. None of it, of course, would prevent the United Kingdom being brought before the Strasbourg Court to justify derogation under Article 15 of the Convention. So my view is potentially very troubling in respect of the domestic implications, but maybe thought potentially futile in respect of our accountability before Strasbourg.
Thank you. Ellen.
Yes, I may be wrong, but I think the Belmarsh case was the only occasion in 20 plus years in which a derogation has been struck down. And I think it's really important to understand why they struck it down. The court said national security, something we keep really hands off. But if you are going to lock up a suspected international terrorist if they are not British, but not if they are British, that is discrimination. What is the reason? It can't be about can you send them back to where they came from, which was the argument. So what is the reason? And if we were to say that we were going to immunise derogations, even discriminatory derogations, and simply say those were beyond the scope of the law, we would be undermining the fundamental basis for the Human Rights Act, which is everyone has equal dignity and worth. Yes, sometimes rights are restricted, perhaps in quite draconian ways, individual rights to protect the rights of others. You think of control orders and things like that. Sometimes that happens, but it must be on the same basis for everyone. And if you start to say there are different rules for British nationals and non-British nationals in relation to who can be locked up on a precautionary basis, or perhaps Muslims and non-Muslims, or right-wing terrorists and left-wing terrorists, you really have got a recipe for undoing the whole universal basis of human rights, and it's very dangerous.
Thank you. Joshua, would you like to add anything on this,
Yes, I
point?
would.
Thank you.
It would not be surprising if the Belmarsh case was the only challenge to a derogation, because we haven't had any derogations in force for many years. There are none in force at the moment. There is one reservation, which goes back to 1952 and relates to the right to education. That doesn't seem to have caused any problems. It's also important to understand, and you, Ms. Cherry, understand this very well, that the Human Rights Act does not give the UK government, any government, the right to derogate. The Convention gives a government the right to derogate, and in very, very limited circumstances. There has to be a time of war or other public emergency threatening the life of the nation. And then the government can derogate from its obligations only to the extent strictly required by the exigencies of the situation, and provided that such measures are not inconsistent with its other obligations under international law. So the question is, what is going on here? Well, we know, because I've mentioned this already, that the Overseas Operations Service Personnel and Veterans Bill is going through Parliament at the moment. And this will put a new section 14 capital A into the Human Rights Act, which will say, in relation to any overseas operations that the Secretary of State considers are or would be significant, the Secretary of State must keep under consideration whether it would be appropriate for the United Kingdom to make a derogation. Well, that's fine. Nothing wrong with the Secretary of State keeping this under consideration. But if the government actually intends to make a derogation in relation to any overseas operation that may be conducted in the future, then it will no doubt be challenged. And the government is presumably anticipating a challenge to to Article 15.1 of the Convention, because people will say that some overseas military operation does not threaten the life of the nation. And so the question then would be, well, what will happen if there is a challenge to an order made under Section 14 of the Act, which simply puts the derogation into effect in domestic law? And the answer is, well, maybe the courts will refuse relief, assuming that the courts were to decide that the ouster clause was valid. And then the consequence of that would be that the UK would probably be found to be in breach of the convention if the case went finally to Strasbourg. So I think what is behind this, to sum it up, is that if there were to be a limit on the ability of the court to grant relief in such challenges, the consequence would be that the government might win the day in the domestic courts of the United Kingdom, but would lose in Strasbourg.
Thank you. That's very helpful. If I can move on to my next question, which is not completely unrelated to what we've just been talking about. It's now settled case law that the convention can have extraterritorial effect in exceptional circumstances. And in circumstances where it's not possible to comply with specific rights in overseas military operations, the government can derogate in accordance with Article 15. And you've just mentioned what they're planning to add to that in the bill currently going through at the moment. In the light of that, is there a case for further limiting the ability of individuals whose human rights have been breached to have their cases determined by the UK courts? And what would be the advantages and disadvantages of such a move? And I'll maybe stick with you, Joshua, because it's very much following on from what you've just been saying.
I think this is what the government is thinking of is the Al-Skaini case, which concerned the killing of 6 Iraqi civilians by British soldiers in southern Iraq. In 2007, the House of Lords held that the Human Rights Act did not apply to the soldiers' actions unless they were on base. The Grand Chamber of the Human Rights Court decided subsequently that the UK government had a duty to conduct an effective investigation into the deaths of all civilians killed by British soldiers, whether or not they were on base. And that was because the UK had assumed responsibility for the maintenance of security in southern Iraq and was exercising control and authority over Iraqi civilians. Now, leave aside whether that circumstances of that nature are likely to occur again. Nevertheless, if they were to, well, yes, the government would have an obligation to conduct an Article 2 compliant investigation into the use of lethal force by soldiers. In other words, were they entitled to open fire? Were they acting in self-defense? And so you asked me whether there is a case for limiting the rights of individuals to have their cases determined by the UK courts. And the question then is, well, if they're going to not be able to bring their case before the UK courts, then where will they bring their case? They must be able to bring their case in some way before the British government. There must be some way in which they can enforce the rights which the Strasbourg court has said they have to make sure that there is a proper inquiry into any abuse of powers and even under a derogation. So the advantages of it being decided by UK courts is that we can be in control of it. The disadvantage is if we lose control of it, then Strasbourg will presumably find against the UK government in the future, as we've been saying throughout this evidence session.
I suppose also there's possibly a problem with what's called the optics of Strasbourg wrapping the British government over the knuckles rather than a domestic court?
Well, I think that may be, something behind the government's thinking. It's one thing for the UK courts to rule against the UK government. That's harder for a UK government to get round. It's much easier for a UK government to blame what is perceived to be a foreign court for reaching exactly the same decision.
Despite the fact there's a British judge on the court.
Exactly so.
And sometimes
exactly
sometimes in the past a Scot. Helen, can I ask you if you'd like to add anything to what Joshua said on this particular point?
No, I agree with Joshua, and I suppose the point is it is exceptional for there to be extraterritorial jurisdiction. It only happens where British forces or agents or officers are exercising jurisdiction beyond the territory of the UK, which is unusual. But if state power is exercised by British executive, agents of the British executive, then it seems to me that it ought to be supervised by agents of the British legislature, because where there's an action, there should be a legal remedy, and it makes sense for that remedy to be the same wherever state power is exercised.
Thank you. Richard.
Can I give us a slightly elaborate answer? Just because I've, for good or bad, I spent a large chunk of the last sort of 10, 15 years doing most of the kind of cases in the domestic courts arising out of it, both representing people who are victims of things that have gone wrong, sometimes horribly wrong, in Afghanistan and Iraq, but also for servicemen as well, and the families of servicemen and women. Article 15, I think there are two parts to your question, Joanna, as I would see it. Firstly, Article 15, and could there be an effective derogation? It's difficult to see, to take Iraq and Afghanistan, how it could be said that the conflict there presented threats to the life of this nation such that there could be a lawful derogation. Whether or not, even if it did, it would be a good thing to derogate on, I have some pretty clear views, and I think it would be a deeply retrograde step for a number of reasons. Firstly, it would be somewhat redundant because, say for one element, common law does that, or which the Human Rights Act does. So all the claims that have been brought overwhelmingly successfully by victims in Afghanistan and Iraq of mistreatment and false imprisonment have all been done, I mean, often together with the Human Rights Act, but have all been done under the common law. And that would continue irrespective of whatever happens to the Human Rights Act. So to a large degree, it's redundant. The one area that the human rights add something is under the Article 2 case law, the obligation is not simply to protect life, but where life has been taken in circumstances that give rise to a suspicion that it might have been unlawfully taken, there's an obligation to investigate. And that whole line of cases has led to the courts ordering investigations. Now, there have been two high-level ones, both of which really served an exceptionally important public service. The first was Baha Musa, who was the young man who was tortured to death by British troops, and the courts ordered an inquiry. And that very detailed inquiry was obviously extraordinarily powerful in terms of giving victims the voice, but was also, I would suggest, extremely helpful for the armed services in understanding where they went wrong and how they could ensure it didn't happen again. And it also reiterated, as part of their evidence as to what happened, the importance of the Human Rights Act, because it showed evidence that at the time in Iraq, there was a discussion as to whether or not the Human Rights Act applied, and a decision was taken wrongly that it didn't. And many of the military personnel thought that made a difference.
Yeah.
The other inquiry was the Al-Swadi inquiry, which is the one that had an awful lot of publicity because it resulted in findings that many of the allegations were untrue, and there was wrongdoing by one of the lawyers involved. That also, may I say, formed an exceptionally important public service because it led to the clearing of the names of service personnel. Now, had there been no Human Rights Act to enforce an investigation, it would all have been left to rumour in the press, hanging over these personnel for the probably the rest of their lives. But the Article 2 investigation provided real public vindication, and that was it doing what the Human Rights Act does. So it performs, in those senses, an enormous public service. And there have also been ongoing investigations under a judge into fatalities, which I'm sad to say have produced some shocking findings, but have again an opportunity not only for victims to have redress, but for the armed services to learn lessons. And there are many people at the top leadership in the Ministry of Defence who want to learn the lessons, who don't see this as a bad thing. The other, as Joshua has alluded to, the other sort of really troubling consequence, if we were to tinker with the extent of the territorial jurisdiction, is, as Joshua said, this would just go to Strasbourg rather than be dealt with by our own courts. But even more troubling, not least I think as perceived by many senior military personnel, taken in tandem with the Overseas Operation Act, will mean not simply scrutiny of our cases before the Strasbourg court, but will mean British soldiers at risk of being dragged to the International Criminal Court in The Hague, because whereas the Human Rights Act will provide the mechanism for this country to show we have properly investigated, which would mean that the ICC does not have jurisdiction, absent that, our troops are going to be placed at risk of being dragged to The Hague. And that is a cause of grave concern to all of us, but I know it's a concern to senior military personnel.
So it's a concern not just in terms of reputational damage for the United Kingdom, but also a concern to servicemen and women and the military authorities.
Yes, most of whom are proud to be promoting human rights, and to whom the notion that they would behave in a way incompatible with human rights is utterly repugnant. But they know that the standards in place, including those by the Human Rights Act, not only reduce the risk of those incidents arising, but when they do, or when there is a suspicion of it, particularly if there's an unjustified suspicion of it, there is protection for those personnel.
Thank you. That's a very full and very helpful answer. Graham, can I come to you finally on this last point? Is there anything you'd like to add, or would you like to take an alternative view on it? It'd be really helpful to hear from you.
Well, I should just acknowledge that Richard Hermer's answer there is very powerful, and it's, I'm sure, strongly persuasive, and I've listened, closely to what he said. I think it's important. My role in this panel, I think, is to offer the alternative views. I think it is important to note that we've seen over 20 years the judicial expansion of the extraterritorial application of the Act in ways I think would have surprised people if we were to reverse the clock back into 1998. Joshua Rosenberg mentioned the Al-Sakini litigation. I think it's important to note that Lord Bingham, a very esteemed jurist, he was in the minority in the House of Lords there. He reasoned that the Act should not have any extraterritorial effect at all, I think, because of the presumption that statute should only apply within the UK. So that shows that I would suggest it's an argument to authority, but there's a respectable intellectual argument there to explain why the position in 1998 was a sound one within our legal tradition, though I note the points that Richard said about common law alternatives. I have read material that suggests that some senior military have concerns about the Human Rights Act through this extraterritorial application displacing the law of armed conflict in regulating armed servicemen overseas. And I've heard an argument made that, according to those military people, that the law of armed conflict is seen as a better suited legal regime for providing the rule of law over our overseas operation. And there were concerns about that the Human Rights Act might encourage a culture of risk aversion and undermine fighting capacity. I'm not in a position to speak to whether those arguments are sound or whether they're widely shared, but I've certainly read in materials and heard people make those arguments.
Thank you very much. Thank you.
Thank you. Could we go to Lord Singh for the next question?
Thank you, Chair. Good afternoon. My name's Inderjit, Lord Singh of Wimbledon, a crossbench member of the House of Lords. The UK has accepted a legally binding obligation to secure to everyone within its jurisdiction the rights protected by the Convention, and has undertaken to provide an effective remedy in cases of a breach. Do you think it would be possible to place territorial limits on the application of the Human Rights Act in a way that was compatible with these commitments? If not, would a separate system of enforcement be required for those whose human rights have been abused by the states overseas? Would there be any advantage in this approach? Helen, could I ask you to start us off?
Good, if I can unmute. Thank you. Yes, I don't think there would be an advantage, and really, I think it's because of that principle of universalism that if there is exercise of state power, it usually will be within the territory of the UK. But if it isn't, then it's still exercise of British state power. And it seems to me that the remedies that the British Parliament has said should apply ought to apply wherever that power is used. I suppose you could put in place separate legislation. I don't think it would be very attractive. And if you don't, then you have all the problems that Richard's just talked about. I don't think I can really improve on what he said about that, which was, I thought, spot on.
Thank you. Joshua, would you like to continue in comments?
Thank you, Lord Singh. First of all, I don't think it would be possible to place territorial limits on the application of the Human Rights Act in the light of the judgment we have just been talking about. So we're talking then, let's imagine these Iraqi civilians, bereaved Iraqi civilians, wanting a proper investigation into the death of their sons. And the question is, would a separate system of enforcement be required for those whose human rights have been abused by the state overseas? The answer to that is no. There is no reason why there should be a separate enforcement. I agree with Helen. Would there be any advantage to this approach? I can see practical advantages to this approach, provided it was possible for victims, or in this case, the families of victims of British troops, to establish whether or not their loved ones had been lawfully killed. If it was possible to set up such a system in the location where these families live, so they don't have to travel to the UK, or they don't have to rely on lawyers in the UK, I can see a practical advantage. In other words, if you export the court to the place where the breaches of the Human Rights Convention may have occurred, I can see that as an advantage. But it's absolutely essential that you are exporting the law in exactly the same way as it is applied within the United Kingdom. You export the judges, you export the lawyers, and you simply do this locally in accordance with the Human Rights Convention. If you are providing the same quality of service, the same standards, the same outcome to people in their own countries, well, that may have an advantage. It might even save taxpayers money in the long run. But it mustn't be any diminution in the rights that these people are entitled to.
Thank you. Would both options be of advantage to the complainant?
Would both options be of advantage to the complainant? You mean they would be able to choose whether to take their case to the UK or whether it could be dealt with locally? I can see that from the complainant's point of view, that would be good, because some may think that they would only get justice in the UK and that cases wouldn't be covered by the media if they were enforced locally. Others would see the advantage of not having to travel and being able to come along with their families to a court hearing locally and be able to do so more easily and cheaply. So yes, giving the families an option, I think, would be an excellent idea. I agree.
Thank you. Richard Pan, would you like to come in?
Yes. Thank you, Lord Singh. I mean, I don't disagree with anything that's been said. Can I just give you just a kind of an insight into having worked on these cases, most of which, I should say, don't involve people coming over here. I mean, in terms of numbers, most of these cases were about people who were unlawfully detained, and a system was put in place with the MOD and solicitors acting for them, whereby the the strength or weaknesses of the case could be ascertained, and they were all dealt with without people needing to come over. Where people did come over was for the most serious cases of allegations of torture and mistreatment. And I have to say, it was watching the experience of people come to court, be listened to, tell their version to somebody, to a judge who was listening, to see the witnesses from the other side have to come and give evidence and be cross-examined, and to receive reasoned judgments, which, as it happens, vindicated their rights. To see the reaction of Iraqis to that, Iraqis who had suffered at the hands of the British, actually I found a deeply patriotic moment, I have to say, because it vindicated the rule of law in this country. And they came out of this experience with an immensely positive view of this country, despite everything that they had been put through. And I just felt exceptionally proud to be part of that. And it's just a kind of a human element as to what the Human Rights Act is capable of bringing and what the rule of law does through it.
That's interesting. Professor Gregg, would you have you any further comments?
Oh, I think that's quite a powerful comment. I'm not sure of anything else to add.
Thank you all.
Okay, thank you. Could we go to Karen Buck for our last question, please?
Thank you very much, Karen Buck, Member of Parliament, Westminster North. Really just it's a roundup question, and thank you for your very strong evidence this afternoon. But I think on the basis of the evidence that we've heard as a committee over these hearings, most people, not everybody, most people would back the idea that the Human Rights Act has worked well in practice. And I just wondered if you could reflect on the extent to which there is a problem with perception and the way that some of the way that the government is now proceeding is in part shaped by a perception of problems with the Human Rights Act rather than its substantial operation. And whether it might be better to actually devote some attention and resource to challenging the perceptions of the Act rather than amending it. So just a kind of general reflection on that as we come to a conclusion. I don't know who'd like to begin.
All right, well, I'll try. I think what your committee has done is to challenge the misperceptions or misconceptions of the Human Rights Act. The interesting question is where those misconceptions are to be found.
Well, what's the answer? Who's driving these misconceptions? Yeah, could it be 102 Petty France? I couldn't possibly comment. Sorry, I lost you. There was a bit of echo on that.
I was just being very rude about the government. I was saying that there are misconceptions.
Sorry, Karen.
No, I was just, as you were, encountering speculation as to where that might originate from.
Could those people who are not speaking go on mute? Because we've got a lot of feedback. Thank you.
Helen, can I invite you to reflect on this?
Yes, I mean, I think the great successes of the introduction of the Human Rights Act was the way that there was an enormous programme of official and judicial education about the Human Rights Act, and the Judicial Studies Board went and trained every immigration adjudicator, every employment tribunal chair. You know, it was an enormous sort of mass exercise, and I think that was really helpful. But that, I think, did perhaps lead to the perception that this was something that was all about judges and lawyers, because the other people who needed to be educated were children and community groups. And it did need to be advanced, I suppose, in the way that the vaccination programme has been, as something for all of us. When you need it, this is where it is. If you're an elderly person and you can't be put in a care home with your life partner, the Human Rights Act might be able to say this is a breach of your human rights. If there's a social security rule that has been drafted for general policy reasons, that there's a government that thinks it wants to cut housing benefit, that's a political choice that an elected government is entitled to make. But if they haven't realised that if you if you have a lot of disability-related equipment, you may not be able to share a bedroom with your spouse. You may need a separate bedroom. That's a human rights argument. These are things that apply to everybody. It's not just about difficult people. It's for everybody in moments when they need it. And I think if we had been able to feel proud of the Human Rights Act in the way that people are proud of the National Health Service, then I think there wouldn't be a question of wanting to tinker with it or do away with it or seeing it as some sort of left-wing plot to subvert the current government. It just isn't. It just isn't. You can disagree with some judgments. You can argue about whether all judges understand it properly. But it really should be seen as a universal thing. And I think it's very sad that it isn't. And I think if there were some programme of public education, then we'd be in a much better place and we'd be able to start to talk to one another about when we limit our own rights and duties to protect those of others. And I really don't see that as a party political project. And I think it's very sad that it appears to have become one.
Thank you very much. Graham?
Thank you. Well, I agree that there probably is a problem of perception that has, been really since the inception of the Act. And, I agree with about the comment I think that Helen Mountfield made earlier on about some of the press coverage of people in society who are deemed to be undesirable or undeserving. And I absolutely agree with Helen Mountfield about human rights being for all. That's partly why people who come from the sort of intellectual position that I'm standing in, who are concerned about the fact that rights are contestable, try to understand or think about institutional responses that will enlarge the opportunities to debate rights in political arenas, and therefore are concerned about institutional developments that seem to be expanding the judicial role and confining the role for political authorities. And I think part of the reason why this committee's consensus might be because there is a dominant or an increasingly dominant mindset amongst lawyers and judges that is, I suppose, different from the sort of arguments I've tried to put today. I suppose I'd just close by saying, from the kind of cold perspective of an academic constitutional lawyer who's not a practitioner, who's not in a public authority, and who's not in a territorial human rights commission, my concern is about how do we secure the durability, effectiveness and legitimacy of our constitutional arrangements over the long haul. So what's going to be the position in 20, 30, 40 years' time, starting from the position that we all pretty much are signed up to the same vision or a vision of the common good? How do we secure that in a way that actually keeps our constitutional intact? So that's the kind of position where some people who share my concerns are thinking about what's the place of the Human Rights Act in our constitutional system? How can we improve it in ways that secure that durable constitutional order?
Thank you very much. Richard.
Yeah, I agree with much of what's been said. I mean, we all acknowledge there are huge misconceptions, one of which is just tied up with Europe and the European debate of the last 20 years. I mean, the number of people who confuse the European Convention with the European Union. And I mean, friends of mine who are I always thought were kind of well-informed journalists or politicians who sort of said, well, now we're leaving Europe, it must mean we're leaving the Human Rights Act. I mean, it's just real confusion over it, I think, in the minds of lots of people, and that hasn't helped. And the second confusion is, I mean, every time I sort of tell people what I do, if I'm chatting to people, I'll get this kind of litany of cases. Oh, well, what about this? What about that? And there are either cases which have nothing to do with the Human Rights Act or which the courts have refused the application. So there's a lot of misinformation about it. And then as Helen said, this should be a kind of a cause of celebration. The idea that as a kind of collective community, we are proclaiming these are the rights that we all have. And it should be a positive thing. And I think the type of campaigns, as Helen was saying, that shows what this means to all of us, it would be a very powerful way of entrenching the kind of the core British values that lie at the heart of the European Convention.
Thank you very much. Back to you, Chair.
Thank you. To be fair, as well as hearing from lawyers and judges, we've also heard from those at the front line, if you like, in relation to the Human Rights Act, including the police, the Crown Prosecution Service, NHS Mental Health Trust. So we've been looking at those people who have to act within the Human Rights Act, as well as those who are applying it in the court. I think this has been a very, very interesting evidence session. And I'm very grateful indeed for all 4 of our witnesses here today. And I think that what we've had the opportunity of doing is shining a light with your very considerable expertise, all of yours, on the very particular questions that need to be addressed. And I think that whilst we can all agree that it's worth respecting the views of those who come to a different conclusion, our job is to look at the evidence of what those conclusions are based on. And if those people who come to a different view have got no evidence to support their view, I don't think this committee will back them up or respect their judgment. Our job is to drill down and to look at what generalised concerns, prevalent fears might be actually based on, and whether or not the remedy is that which is being put forward. So having said that, we will proceed with the assistance of your evidence and all those who've given evidence to this inquiry to give our report to the Independent Review on Human Rights. So thank you very much indeed for your contribution this afternoon. That ends this committee session.